Hi, welcome to Friday, December 4th. You're here to talk about the new chapter in bankruptcy with Mike Markham, an amazing bankruptcy lawyer, and Ken DeGraw, an amazing forensic and tax accountant who specializes in bankruptcy matters. I'm really looking forward to seeing some conversation and some synergism here and talking about ways that you can help clients who hopefully won't have to take bankruptcy, but can use this as a negotiating tool, or on a worst case scenario, we can see what would happen in the bankruptcy court. Now, this builds on a couple of previous webinars that you may be interested in if you are a tax advisor, if you want to know about how bankruptcies work, and especially tax related issues concerning insolvency. There's some YouTube videos that are referenced here. If you have problem accessing them or you want the PowerPoints, just let us know. We'll be glad to send them. I've been working with Michael Markham since very early in his career. It was also early in my career. And he looked at a very, very complicated situation for me and completely disagreed with what other bankruptcy lawyers were saying. And he adopted a strategy that really helped that client and simplified things. And then he pulled two rabbits out of two different hats for that particular client. And we've done a lot of work since. If you are an estate planning lawyer or a non-bankruptcy lawyer and you are giving creditor protection advice to your clients, I strongly recommend that you find a Mike Markham and make sure that they're involved in communications that you have with clients, and quite frankly, instructing you on how to have communications with clients that might be running into problems. Ken DeGraw, we're going to hear a lot from. He is nationally known and a thinking leader and a teaching leader in this area. So Ken, let me turn this over to you, and why don't you just take 10 or 12 minutes and let us know what your conversation is with a client or with an advisor when they are thinking about the bankruptcy card being played.
That's great. Thanks, Alan. This is such a great opportunity for clients who are having a very difficult time of it. And certainly there are a lot of them out there right now that are really struggling. Uh, the Subchapter 5 rules are put in place, and Mike's going to talk about them in some depth in a minute, really provide a unique opportunity that has not really been there before. It's been so difficult for businesses looking for an opportunity to remake themselves, to get out from under the debt strangle because of the cost and the time involved. That Subchapter 5 just provides a fantastic opportunity. So I thought I'd take this initially because I have talked on this a few times, but it's been mostly in terms of educating other professionals. But I thought I'd take this one and really direct it more at the business owner and what they need to be thinking about as they begin to approach a consideration to file or they're experiencing financial distress. The businesses that we're talking about, they're relatively small. The debt limit is only $7.5 million. So in the grand scheme of things, those aren't large businesses. They are typically family owned or family run, or the people that work there have been there a very long time and they may as well be family. So any decision and difficult financial road that they're on is just gut wrenching. They haven't had to experience this before and they really don't know how to confront it. And let's face it, a lot of these folks, they're really good at what they do. They are the best service provider on the planet. They are the best widget maker on the planet, but they're probably not the best back office people and strategic thinking people on the planet in terms of moving their business forward. So they need help. They need, and I'll get to that in a minute in terms of the professionals that they need to bring to the table. Some of the stuff that business owner, and Subchapter 5 is unique in that what we're seeing in statistics is that almost 25% of the filings under Subchapter 5 are individuals, meaning sole proprietorships and single member LLCs. So these are really small businesses. They're not even the local Main Street businesses. So the first thing they need to think about is, can it be fixed? Did they have a really good business plan prior to the pandemic hitting? And if, but for that debt load that they've incurred over the last 8-9 months, and they can come out of that, can this business plan be good going forward? And that's a really important decision that needs to be made. Can it be fixed? They need to look at all of the contracts and loans and agreements that they've gotten themselves into over the years, the business structure that's been built to determine whether or not it still fits the ongoing business plan. And bankruptcy provides opportunities for people that have brought on more real estate, for example, in the case of retailers, that maybe they need at this point in time. Personal guarantees are huge for businesses of this size. The individuals have guaranteed the loans, they've guaranteed things to vendors or customers. That impacts the individual as much as it impacts the business. And that needs to be vetted through. Cash flow is always king. We need to look at related parties, whether it's businesses or individuals, and make sure that the transactions have been at arm's length. And that needs to get vetted out. Zone of insolvency is a legal theory that deals with when that business owner becomes insolvent and now their obligations are to their creditors instead of their customers. I'm sorry, to their shareholders. I won't get into the weeds on that. That's a conversation for another day. But I mentioned before the professional guidance, and it's so important. Most businesses have a business attorney that they work with and a tax preparer or a local accountant that they may be working with, and they're probably doing a fantastic job, and that's great. But the reality is bankruptcy is specialized. As Alan alluded to a minute ago, you need guys like Mike who've been there and done that. Guys like myself on the financial side who've been there and done that, who can lead you through this process. It's not built for the average professional to be able to manage. So think that through and make sure you're getting some good recommendations. You need to think through whether or not you're going to reorganize or liquidate. And that's another gut-wrenching decision, particularly for a small business, to have to face. You need to figure out a communication plan with your customers and your vendors and your employees. I just recently did a Subchapter 5 case with a golf course here in New Jersey where I spend most of my time. And they were pretty far down the road and were just about to file. And for whatever reason, their attorney, he was actually a trustee in Chapter 7, didn't even bring it up to him, but they had all kinds of constituencies that they had to deal with. And they hadn't figured out a communication plan and who was going to be talking to these folks. The last thing they need is all the members of the golf course bombarding all of the people who happen to work there with questions about the bankruptcy. They don't know the answers. It needs to get directed and focused. Websites need to be developed, which is one of the more typical ways to get things done with email addresses. And most important, I'm sure Mike will touch on this one, is if you're going to file for bankruptcy, and I don't care what the chapter is, you need to figure out how you're getting out before you get in. Because otherwise, you may never get out, and you'll be doing what's known as a Chapter 18 and filing for liquidation when all is said and done here. And I'll kind of wind this up here in the last couple of minutes with just once that decision's been made, as hard as that getting to that decision may be, what comes next is even harder. And that's pulling together all of the information you're going to need to be able to bring the filing to the court and file that petition, working with your professionals. A lot of these businesses have probably barely ever had a board of directors meeting, let alone an annual meeting. The corporate governance needs to get brought up to date so things are appropriate. Financials, a lot of these businesses only have a bookkeeper. They don't have full-blown financial staffs. You need financial professionals who can help you bring your financial information up to date, because there is going to be a microscope stuck right into your general ledger, and people are going to want to know what you've done, how you've done it, and why you've done it, and there's going to be a lot of questions. Taxes need to be up to date. You're going to need to be able to provide tax returns. The IRS and the state that you happen to be in are going to be acutely attentive to what you've done or haven't done, and they're going to be first in line to get paid with the dollars that are out there. You need to accumulate vendors lists, liabilities, and vendors that have priorities and the amounts that you owe them. Whether or not you think you actually owe them the money, if they're out there and they're claiming there's a balance due, they need to get listed, or guess what? They're not going to get discharged in the bankruptcy. I already mentioned the contracts, the loans, and the leases. You'll be amazed as you start pulling the onion back here, what you're going to uncover that needs to get disclosed and identified, and the questions that are going to get asked. Whether or not these things are even enforceable or even enforced. Sometimes the security agreements, I'm sure Mike might even mention this, don't even get renewed, and what we thought was a secured agreement is no longer secured. These are things that need to get vetted through early on. You need to look at your assets and what their values are. That can be a challenging environment, particularly if you've got real estate or a large amount of equipment. If you're a manufacturer, what's the value of this stuff? Rolling stock. I did a distributor that had a significant amount of rolling stock, and they had to go through and value every single one of the tractor trailers that was out there. It's an enormous undertaking. Um, and it all goes to condition and length of time, and there's all kinds of issues that come up. And again, kind of last but not least here is insurance. You need to have insurance in place in order to file. It's one of the questions that's going to get asked. But things like directors and officers insurance is really important. Making sure all of your other normal insurances are in place. The D&O is in place because if you've been making decisions that maybe weren't in the best interest of your creditor body, somebody may be knocking on the insurance company's door saying, hey, we want to put in a claim against the D&O policy because they haven't been acting in the best interest of the creditor body. And there's some issues out there. So kind of laying that stage here, there's a lot of heavy lift that needs to be done. I'm going to let Mike now dive into the specifics of Subchapter 5 and bankruptcy in general, and I'll wind it up later on with what happens in a case once you're in there and the kind of financial due diligence that needs to get done.
Beautiful.
Okay, thanks, Ken. And I want the audience to know that Ken and I met earlier this morning before this started. But I must say, Ken's presentation just then is exactly the due diligence items that you've got to go through. Every single line item he said is so critical. Most importantly, that exit strategy. People, when they're in financial distress, they panic and they stop thinking and they just run into a bankruptcy lawyer's office and they file because they find a guy on a corner that'll file a case for them for $4,000 or $5,000, and then they're in and they get the automatic stay, and then they find out they're going to be out in 30 days. Total waste of time and effort. You've got to focus on that exit strategy. Where am I trying to get? And then Ken, a question for you. You talked about, the financial systems that people have in place, and I think that's on the next slide, Alan. How often, when distressed businesses come to you, do you see what you would view as sufficient financial systems in place?
I'm laughing because the number is probably in single digits. I do a lot of work with bankruptcy trustees in Chapter 7, and I literally tell my staff, use the records to the extent you can, but don't trust them. We go right to banking records and third-party sources because the records are such a shambles.
Yes. So everybody listening, if you're the prospective client, if you're a business owner, if you work with your own accountant that doesn't think and talk like Ken does, because Ken talks like a businessman. No offense to the accountants, but a lot of accountants count beans or do taxes, but they don't run businesses and they don't help clients run businesses. You need that kind of accountant because on the way in, the reason that you're probably in the spot you are is that you didn't have proper financial systems in place. Because Ken and I both know that less than 10% of our clients have sufficient financial systems in place. They don't know what they're spending money on. They don't know what they're paying for payroll. And if they're a manufacturing company, they never know what their cost of goods sold is because they've never sat down and figured out how much labor and material and occupancy cost, for example, go into making a widget. And that's complicated. And the average, widget maker that's a great widget maker doesn't understand that. And so if you get an accountant like Ken involved, he can help you get that out. And then you'll find out, and this is what a lot of debtors are doing. It's the old saying, they're making it up on volume, meaning they're losing $1 per unit and they don't even know it. So the way you can never talk to me is by talking to Ken on day one. And I don't want you to ever talk to me. I hope the only time you guys see me is on this webinar. But if you'll go to Ken in advance, I don't think you'll ever get to me, or you still might, but for a different reason. But don't get to me because you didn't understand your business, okay? That is so important, and that is the biggest lesson that anybody can take away from a pre-bankruptcy discussion. So now let's move on to subchapter 5, because this is a new exit strategy that didn't exist before. And understand, it went into effect originally in February of this year, 2020, with a 2.5 million or 2.75 million cap. Okay. When COVID hit in March, they raised it to 7.5 million. So let's compare that to what was already out there, right? Because you have chapter 7, which is a liquidation chapter, which, you know, if you're liquidating, you're liquidating. You're not reorganizing. You don't need to go through most of this due diligence, except in order to get to the decision to file chapter 7. But in chapter 13, that's for individuals only, and that's for individuals that have no more than about 420,000 in unsecured debt and no more than about 1.25 million in secured debt. So you could have a total of about 1.6, 1.7 million in debt as an individual and be eligible for 13. But if you had over that number, you weren't eligible for 13. The only place you could go is chapter 11, and that was the old big chapter 11, the same one that General Motors and Enron filed. Doesn't fit that well for mom and pop in a sole proprietorship. And chapter 13 has never been available for a business that's incorporated, an Inc., an LLC, a limited partnership. So with this up to 7.5, and it'll be interesting to see, given the way COVID is, when we get back around, will we be done with COVID, or will Congress extend that $7.5 million cap amount? Because that really makes it available to a lot more small companies that I think really need it, and I hope they do keep it. So the requirements are is that you have to be engaged in commercial or business activities. I think that's been pretty broadly construed, because one of our judges in Florida has determined that that applies to a nonprofit homeowners association. So an actual nonprofit. So engaged in commercial or business activities doesn't mean you're doing it for the purpose of profit. So you could be a nonprofit, any kind of nonprofit. But if you're, I mean, because in bankruptcy, there's business and there's consumer. So if you have an entity, odds are you're in an entity to engage in commercial or business activities. So I think virtually any business is going to be eligible, as long as they're, one, under the 7.5 or 2.7 million cap, whichever one applies, and more than half of their debt is business debt. That's only really going to apply in an individual case. So let's just talk about that real quick. So let's say you have an individual and he has a business that's a sole proprietorship, so it's run through his own name. But he has a big mortgage on his house. He has $1 million mortgage on his house. Well, if he has $1 million mortgage on his house, that's a consumer debt. If he has 900,000 in business debt, he's not eligible, because he's got more consumer debt than business debt. You won't see a lot of those, and I know that's pretty small, but you can see some professionals, doctors, others that can have big consumer debt, giant mortgages, $3, $4, $5 million. So you got to know that when you're going in, because that's the eligibility. But a lot of people are going to be eligible for this subchapter 5. And let me just say, so far, and I don't know what the next, I want to show me the next slide, Alan. You know, so far, with COVID and all the CARES Act money that got in, and now we're expecting some more, people have not filed bankruptcy yet on a business level, because they've been propped up by PPP and other kind of CARES Act loans. And oh, by the way, you can't get a PPP loan if you're in bankruptcy. And so a lot of people have held off in the SBA application for a PPP loan. There's buried in one of the questions, are you involved in any bankruptcy case? And so now I have had a couple of clients that did get PPP loans while in Chapter 11. One from actually their bank that was their DIP bank that absolutely knew that they were in Chapter 11, but they gave them the loan anyway. But there's a lot of litigation going on those, and I think that there's a split. I think there's going to end up being a split in the circuits on whether the SBA exceeded its authority in enacting those regs that prohibited Chapter 11 debtors from getting PPP loans. It seems kind of odd to me. I don't know why they discriminated against Chapter 11 debtors. The point of that PPP loan was to keep people employed. And if the Chapter 11 debtors keeping people employed, isn't that achieving the goal that the act was intended to achieve? So that's going to go on, and that litigation at the appellate courts will probably go on well after it makes a difference, because hopefully a year from now, we will be on the other side of this pandemic and we'll be back to getting normal. So Alan, go back to those, the slide that's kind of gets me started. There you go. So let's talk about the major differences with this. And I think the major strategic difference is that you don't really need the vote of any creditor to get your plan confirmed in a subchapter 5. In a regular Chapter 11, you have to get the vote of at least one impaired class. And while that's problematic sometimes, is that you'll have a lender that has a huge deficiency claim. In other words, the value of their collateral is nowhere near their debt. Maybe they're owed $5 million on a line of credit that's secured by all the assets, but the assets are only worth a couple of $1 million. So in bankruptcy, that secured lender has a secured claim of $2 million, but they have an unsecured claim of $3 million. Well, in a lot of cases, that unsecured deficiency claim will dominate the class of unsecureds, and then that debtor can't get the vote of any class. In subchapter 5, you don't need the vote of any class, and you can cram down every class. So let's talk about cram down. As it says right there, it's a generic term for confirming a plan over the objection of a creditor. So when it's a secured creditor, you've got to pay them essentially at least the value of their collateral over time at a market interest rate. Okay, so that's usually not hard to do or not hard to negotiate, because the value of collateral can usually be determined through appraisals, and sometimes you see big fights over that. But everybody knows equipment's not worth anywhere near what somebody has it on its books for. Real estate is usually pretty easy to appraise, although when it's income producing, you can have variations. But you can usually figure out how to achieve a cram down over a secured creditor. Now, but now that you don't need the vote of the unsecureds, and there's no absolute priority rule, the next bullet point. So what does that mean, absolute priority rule? Well, in normal Chapter 11, the absolute priority rule says if you're not paying the superior class in full and they don't vote for the plan, the inferior class can't retain anything. So look at that in a simple mom and pop organization. Unsecured, you have secured creditors at the top, unsecured creditors next, and then equity at the bottom. So under the old Chapter 11, without subchapter 5, if the unsecured creditors didn't vote in favor of the plan, maybe because you have one or two that just don't like you and they vote against it, then the mom and pop can't retain the equity in the debtor. Well, where does that leave you? It leaves you nowhere. Who else is going to have the equity in this mom and pop business? Only mom and pop are going to have the equity. So people had to find a way to get around that, put new money in, transfer the business to their brother, their son, their daughter, their father, and find some way to get around that. But now you don't even have to worry about that. So how do you cram down over unsecureds now? You can keep the stock. It doesn't matter. Everybody knows the stock is worthless from an equity perspective, right? All it does is give the debtor principals control over the business. Who else is going to operate the business other than mom and pop? So if you If your plan as to unsecureds, all you have to provide is one, what they would get in liquidation. And for example, in what I said before about a secured creditor, if all the assets are only worth $2 million and you liquidate the company, guess what? Unsecureds get zero. So in theory, if you pay the unsecureds $1, you've satisfied what's called the best interest of creditors test. The only other thing now in subchapter 5, they've made it like chapter 13, which focuses on projected disposable income. So you have to, in a subchapter 5, you have to commit 3 to 5 years of your projected disposable income into your plan. And that's what, that's what your secured creditor payment's going to come out of, your attorney fees payment's going to come out of, and then whatever your unsecureds are going to get, and whatever other, you have rent and other stuff. So who's going to help you figure that out? Well, somebody like Ken is going to help you figure that out, because they're going to go in and they're going to do that new budget for you, that post-petition budget or that post-confirmation budget. And what are you going to try to do? You're going to try to get that projected disposable income down as low as you can get it through reasonable expenses, because you're entitled to take against your income any reasonable business expenses like salaries. So I had just had a case recently. It was a doctor professional association, one owner, one doctor, one revenue producer, a PA. I was representing the biggest creditor in the case. The doctor comes in and says, well, I've been paying myself about $500,000 a year. I want to keep getting paid $500,000 a year. If the court lets that principal get that $500,000 a year, then guess what? There might not be any projected disposable income for creditors. So I was stuck in a fight of arguing the salary and bonus that this doctor has paid himself historically should not be permitted in a post-confirmation environment. There are no cases on this issue yet. I think in a small professional association, this is a really interesting issue, because I was arguing, we ended up settling the case, but I was arguing, look, the guy's got to take less money. It's not reasonable. The reasonableness test isn't reasonable based on what he did before. It's reasonable on what's going forward. And it's not reasonable for the owner to take out all the money while unsecured creditors get zero.
Mike, there's a side issue there that along the same lines that I ran into recently, and I don't have an answer for it yet, but a lot of these businesses are partnerships and subchapter S's where the income gets passed through to the owners and is taxed at the owner level. Whether or not the business in that calculation of disposable income can make a tax distribution to its owners to pay their tax bill, or whether that money needs to remain in the business entity for distribution to the creditor body. So I don't have an answer, but that one came up recently.
Yeah, there's a really interesting decision, Ken, in the 11th Circuit Court of Appeals, which is our governing circuit down here, where a corporation was a sub S, and as part of the principal's employment agreement, the debtor agreed to pay his tax, burden to him. So the money would pass through, right? It would go from the debtor corporation to the individual to the IRS. And the case ended up in a 7 or a committee, I don't remember, but somebody sued the individual and said that is a fraudulent transfer. You can't do that. The 11th Circuit actually held, the bankruptcy judge, one of our local judges in Tampa, and the 11th Circuit ultimately affirmed and said that's not a fraudulent transfer. That because it's a sub S, and he agreed to keep treating it that way because it was beneficial to the debtor corporation and him personally, that was a proper part of the shareholders agreement and was not a fraudulent transfer. So that would certainly be an instructive case to argue if you got to that point. But yeah, there's going to be a lot of interesting issues. You know what they say, the tough cases make bad law, right? So when you get these tough cases, like you get a doctor that's drawing $1 million a year out, but he's faced with 50 medical malpractice claims. Okay, think about that. That doctor's probably eligible for subchapter 5 because those medical malpractice claims are not liquidated debts. Let me go back for a second. those numbers I gave, the 2.75 and the 7.5 million, those are liquidated debts, promissory notes, rent, stuff like that, not contingent, unliquidated litigation claims. You could have a doctor, a surgeon. I had a case with a spine surgeon about 20 years ago. He got sued about 50 times. He was facing hundreds of millions of dollars in potential verdicts. He could have filed for Subchapter 5, not gotten the vote of anybody, argued that he should be able to continue to take his $1 million a year salary and bonus because it's reasonable, and paid creditors 1 or 2 cents on the dollar, if that.
Yeah.
So you're going to see some really interesting cases when you get that kind of funky lineup of ownership and income. In your normal mom and pop widget manufacturer, I think these cases are going to be pretty straightforward. And that kind of gets me to the Subchapter 5 trustee. Another major difference. In Chapter 7, you have a trustee that controls everything and liquidates the assets. In Chapter 11, you don't have a trustee. You're your own debtor in possession, meaning you're the debtor in possession of your assets. And you remain in control unless you do something stupid, and then they can take you out of control. You lie, you cheat, you steal, you lie on some forms, you don't do your paperwork right, then what's called a Chapter 11 trustee gets appointed. That doesn't happen very often, but it does happen. But then in a normal Chapter 11, you have the Office of the United States Trustee. Don't confuse them with a trustee. The United States Trustee is a branch of the Department of Justice that oversees bankruptcy cases. They just oversee the process. They don't touch your assets. They don't touch your bank account. They don't tell you what you should put in your plan for the most part. But they monitor you and make sure you're playing by the rules, make sure you're filing your reports, make sure they make sense, make sure you're paying your fees, which, oh, by the way, in Subchapter 5, you don't pay U.S. trustee fees. U.S. trustee fees could vary anywhere in the smallest of businesses to $325,000 a quarter up to $20,000 a quarter in the biggest of businesses. Now, you're probably not going to see a Subchapter 5 that's going to owe $20,000 a quarter, but you could easily see a Subchapter 5 case that would owe $5,000 to $10,000 a quarter in U.S. trustee fees in a regular Chapter 11 case. There are no U.S. trustee fees in a Subchapter 5 case. So what does that Subchapter 5 trustee do? We're not sure yet. Different ones are doing different things. They're acting different ways. Some of them are guys like Ken. They're very pragmatic and business oriented. Some of them are lawyers like me that aren't business oriented, but they know the legal, maneuvering. But some of the literature leading into this suggested that they would be de facto mediators, that they would get between the debtor and its creditor constituencies and help them negotiate a consensual plan. Because if there's a consensual plan, the Subchapter 5 trustee disappears at confirmation of your plan. If you have to cram down and you don't get consent, the Subchapter 5 trustee stays involved, receives the payments, stays on top of you, and then remits those payments out to the creditors. So I haven't seen yet where a Subchapter 5 trustee I thought really got, elbow deep in the negotiation process. I'm not sure they know what their job is yet. It's really early on. They're trying to kind of play it down the middle. My sense is that the lawyer ones are typically debtor lawyers, and they're going to be a little more debtor oriented. I think all of them are probably going to be a little more debtor oriented, because even the ones that are more business advisors, those are people that have worked with debtors. But they're going to be helpful, hopefully, and they're not going to run up a huge bill, because you do have to pay their bill at the end of the case. And I think even in a complicated case, hopefully that would be a number at about a $25,000 fee or something. It could obviously get higher depending on how that trustee. But I think in our district, at least, I think the U.S. Trustee's Office has told them, hey, look, the point of this is not to overburden the debtor with administrative expenses. So keep your expenses down as best you can. So I think the Subchapter 5 trustee is a good idea. I think it's going to be helpful. And I think these cases are going to have a really great chance of success as long as there's an underlying business there that makes sense. And somebody like Ken's going to help you figure that out, because before you ever file, because as we said, you got to have that exit strategy going in. So I think those are the high points on Subchapter 5. Alan and Ken, and if you guys got any questions or clarifications, we can talk a little bit and finish this up.
Just to piggyback on what you were saying, I've talked to a few of the 5 trustees in New Jersey here, all of which are attorneys, and they have really been able to kind of hit the reset button between where there's a strained relationship between the debtor and a substantive creditor, and they're able to get in there and get to some of these consensual plans, because it's just a fresh voice in the room, and it's they really help, and that mediator that you talked about, really making a big difference.
Yeah, in Tampa, we have 1 lawyer trustee and then 2 non-lawyer. So, and they all have different backgrounds. So you tend to get a little bit different approach in each one. But as we have more cases and we learn how these people, handle a situation, that'll provide a lot more certainty to this process. But I think it's been working pretty well so far.
Absolutely. Just before I kind of jump into some of the financial stuff here, one of the things that always seems to catch people a little flat-footed is the concept of use of cash collateral and the review of the executory leases, and how to go about that. Just give a little color on what that process is to be able to get use of what is now someone else's assets, and how to go about some of this analysis.
Yeah, sure. Well, cash collateral, just for people that me and Ken throw that around, we know exactly what it means. Some of you are going, what does that mean? What does that mean? Well, cash collateral is your cash in your bank account and your receivables that are coming in. So they cycle through, right? In theory, you have a manufacturing business, you collect your receivable, you buy them a new material, you build another widget, you sell it, the money goes in your bank, it cycles through. So that is normally the secured creditor's collateral. Typically, you will get permission to use it. You have to get permission to use it. It's a very typical first day motion that gets filed, and in most jurisdictions heard very quickly. But as long as our judges look at, one of our judges says he does a webinar of his own. Will that dog hunt? Which is the whole thing Ken and I talked about. It's the exit strategy. Is that dog going to hunt? Meaning, can this debtor pay its bills going forward? Because if you can't pay your post-petition bills, you're going to be in Chapter 7 in a month or 2 anyway, so why bother? So if the judge is usually going to look at, can the dog hunt? He's going to give the debtor the benefit of the doubt, and you're going to be back in there in 30 days looking again at cash collateral. But normally you get permission to use cash collateral. But it is something where a lot of judges will hold you to, some proof of, show me your post-bankruptcy budget. How are you going to spend this money? What's going to salaries? What's going to rent? What's going to materials? What's going to insurance? And you can't file without knowing that stuff. And you'd be surprised how many people have no idea. You ask them to fill out a budget for their business. They don't even know. You have to sit down with them one by one, take a very simple form that has about 12 categories in it, and say, look, man, go back to do me a favor, give me your checkbook. Let's get your check register. Just show me your check register. All right, let's check off the ones that relate to your building, right? Let's check off the ones that relate to insurance. Let's check off the ones that relate to payroll and benefits, right? Then you categorize them for them, because they have to do that when you have to file when you're in Chapter 11, what's called a monthly operating report, where you have to pigeonhole everything into one of these dozen or so categories. You got to file those in Subchapter 5 too. So if you don't know how to do it, you might as well learn before you go in, because you're going to need it for the report, and you're going to need it to show the judge that you are going to have some projected disposable income that you can pay creditors. So your argument's going to be, let me keep my people employed, let me keep my business afloat so I can pay a little bit of money back to my creditors. Even if it's a little bit, that's better than zero, which is normally what they would get in a 7. Now, as far as executory contracts and leases, you're going to look at those, right? You might have a terrible lease with your landlord. right? You may not need all that space. When you have those kind of contracts, you either assume them as they are and cure the defaults, or you reject them and you get out. On a lease, rejecting and getting out is complicated because it costs money to move. And guess what? Most Chapter 11 debtors don't have the money to move. So I usually tell people, if you're thinking about moving, let's just do that before you file. Because let's incur that expense. Let's make that decision now. Let's get out. Because you don't want to be having to do that while you're in the Chapter 11. But that lease expense is usually occupancy costs, as we all know. Payroll is usually your biggest. Insurances are big. Occupancy cost is big. So those are your three biggest nuts right there. And cost of goods sold, if you have if you're a widget manufacturer instead of a service industry, you're going to have a lot going into cost of goods sold because you're buying materials. But that only applies in that concept. But you got to know these numbers and you got to be able to figure it out. But if you have other kind of contracts that you can assume or reject, you need to look at the benefits you're getting from that contract. And because if you reject one, they just have an unsecured claim for your breach of the contract, which you can deal with, particularly in Subchapter 5 very easily, because their vote really doesn't matter anymore. A lot of times in other cases, if you rejected the landlord, you'd leave the guy with a multi-million-dollar lease rejection claim, and then he'd have some voting power that you wouldn't want him to have. Subchapter 5 probably makes those rejection issues even easier for you because you don't need to be worried about that rejection damage claim that results out of walking away from that contract. But executory contract issues can be complicated. They can involve intellectual property. They can involve franchises. For example, if you're operating a fast food restaurant or some other business that's franchised and you're using their intellectual property, their labels, their name, you can't get, you gotta keep that. You're not going to turn your McDonald's into a McDowell's. That's from Coming to America. You're not gonna change to a McDowell's and still operate and make money. It's not going to work. So when you have a franchise, the exception to that may be with a hotel. I have seen hotels with major flags file and not have to keep the flag because they can go independent because the reservation systems out there are a little different than they were a long time ago before everybody booked hotels on their phone while they're driving. In the old days, they had Holiday Inn on speed dial and they said, hey, I'm going to be near Lake City tonight. Can you tell me where the closest Holiday Inn is? And then they put them in it. But people I'm not sure that that's the way people find hotels anymore. But those are some of my thoughts, Ken.
Cool. Awesome. So I know we're probably getting close on time, Alan. So I'll just kind of round this out with, I mentioned, actually, let me piggyback one comment you made very early on, and that's, understanding your costs. And that's the number one reason why restaurants are the number one business entity that file for bankruptcy, because they don't understand their food cost. And their margins are razor thin to start with. But it just makes all the sense in the world. And just to kind of round this out, certainly the IRS and the state that you're in or states that you're in don't go away when you file for bankruptcy. There are a whole slew of issues that come up. And Alan and I have done a couple of webinars on this already, some of which are not, I'll call it normal, that you don't run into on a normal year in, year out basis. The 800-pound gorilla is cancellation of debt. That you may be getting out from under a significant debt load, but that doesn't necessarily mean you're getting out from the fact that may be income to you. And there's a number of tests that need to be passed to get through that. And if you're in a pass-through entity, we mentioned that before on the pass-through issues with taxability, you can find yourself in a situation where there are issues where that money can't get passed out to you as the individual owner, even though you technically still own it. And when that ownership is in play or not in play, way too much there to even begin to get into, but I just figured raise the concept that there are tax issues that need to get dealt with so that we get some awareness around that one as well.
Definitely can. And to follow up on a couple of your points, if you have an LLC taxed as a partnership, you're in trouble. Because an LLC taxed as a partnership, that debt forgiveness happens at the member level, not at the corporate debtor level. So you file bankruptcy, you've been told there's no There's no debt forgiveness income in Chapter 11. Well, that's true for the debtor. That's not true for the individual member if it's taxed as a partnership. Very dangerous situation. The other point is if you do owe taxes and you're thinking about filing, particularly a Subchapter 5, I might not pay them before I went in. I might intentionally not pay them. Why? They're a priority claim. They get paid ahead of unsecureds, and you get 5 years over time to pay them. So what does that do? That reduces your projected disposable income that's available to unsecureds. So use that money post-petition to pay pre-petition taxes. Maybe it's just a year, maybe, 1 year, maybe it's real estate tax you didn't pay, maybe it's some sales tax you didn't pay, payroll tax, be careful. They'll come after you individually, but you need to be talking to somebody like Ken about what are the pros and cons of paying that tax if you've already made the decision you're going to file, because it might give you more flexibility on the exit.
Thank you very much. Very, very interesting and powerful conversation. Let me just say that if you are a business owner or you are representing business owners and they might need to see someone like Ken or Mike, then they already should have seen Ken or Mike. And you have to be very careful of the approach. You need to hold on to enough money to pay Ken and Mike so you can get into this process. You need to remember that the attorney-client privilege can be a little bit confusing and maybe not so foolproof. Be very careful as to what you put in writing before you talk to Ken and Mike or people like them. And finally, you can do a real disservice to yourself, shareholders, and others by not conducting the business properly before it files bankruptcy. That's already been discussed, but with all the preferential transfer rules and the fiduciary duty to creditors, everybody has to be very careful. Things could get much worse than they already are.
Absolutely.
So Ken and Mike, I really want to thank you not only for a great presentation and for the work we've done in the past, but for your dedication to these issues and, quite frankly, your dedication to helping debtors is really to be commended. You've saved a lot of jobs over the years, a lot of businesses over the years, and I know a lot of people thank you for that. So you have our email addresses. You've got Mike, Ken, and my addresses. Send Mike and Ken the hard questions. Send me the easy questions. Hope you have a great day, and we're always open to your suggestions for future programs. Thank you.